Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And I am so excited to have with us today attorney Jim Sorenson. He owns a law firm called Sorenson Van Leuven Law Firm out of Tallahassee, and they represent credit unions exclusively. And welcome to the show today, Jim. Thank you so much for joining us.
Thank you for having me, Erica. I'm excited to be here today.
Me too. And what I'm really excited about is the series that we're doing on myths that happen within credit union law. And today's myth does not disappoint. We're going to be talking about cross-collateral clauses. And I'd love to hear you first say that 10 times fast, Jim.
Yeah, it can be a tongue twister. Cross-collateral clauses. You can tie yourself up with that if you get going too fast using that phrase.
Absolutely. And, as hard as it is to say, it is confusing, I think. And so I'm really glad that you are here to help clear up some myths about the cross-collateral clauses and really help us avoid mistakes in the future. And it looks like they could be quite costly if you do make mistakes where this is concerned. So why don't we talk a little bit about the definition of cross-collateral clauses?
Yeah, I think it's good to set the table of exactly what we're talking about. Some people watching this video may have heard of them, but don't have a great definition, and sometimes there's even confusion behind what it is. So I think that's a good place to start. Cross-collateral clause is a provision in a contract, and not all loan documents have them, but a lot of the loan documents credit unions use will have a cross-collateral clause. And it's simply a provision in the contract that provides that a lien on a piece of collateral, typically we're talking about a motor vehicle, but it doesn't have to be, it could be any collateral, secures not only that loan. In the case of an auto loan, it secures not only the auto loan, but it also secures other loans owed to the credit union. So stated another way, maybe try to make it clearer, the cross-collateral clause provides that the lien secures not only the loan that creates the lien, but any other loans owed to the credit union. So if you have a situation and the borrower has an auto loan and they grant the credit union a lien on their 2020 Honda Accord, and they also have a credit card, the lien on the Honda Accord not only secures the auto loan, but it also secures the credit card. That's what we're talking about.
Well, I mean, that's really good to know. I mean, one may think that if you have an auto loan with a bank, that maybe it's every single thing you have with the bank, including a mortgage, maybe that means that they can repossess your car or something if you don't make your mortgage payment. I mean, it can be crazy what people may think this is. So I want to hear both what the myths are and then what the real facts are, because that's what we're here to do. So what are some of the misunderstandings regarding cross-collateral clauses that you've heard of?
Yeah, so I think the big four that we're going to talk about today. There are other variations of this, or maybe some lesser ones, but the big four that I hear over, or we see over and over again, are one, that a cross-collateral clause allows the lender to repossess the collateral. Again, typically we're talking about auto loans, so it allows the lender to repossess the auto when the credit card is in default. The second is that the cross-collateral clause is the same as set-off, or has some relationship to set-off. And set-off is simply taking money that's in a deposit account and applying it towards a loan. They are two separate things. And then the cross-collateral clause applies to residential mortgage loans, which it doesn't. And then fourthly, cross-collateral clauses apply to indirect auto loans, and typically they do not. So those are really the four big ones. It goes to understanding the scope and the depth and really how the cross-collateral clause works. And that's what we want to try to address these four myths today.
I mean, this is really good to know and probably a relief to somebody that has a loan that if they get a little bit behind, they're not going to lose their car. So, why is that? Why does the cross collateral clause not allow for repossession of the collateral?
Yeah, in short, the cross-collateral clause simply describes what loans are secured by what liens. So in other words, take the example of the lien on the example of the lien on the 2020 Honda Accord. That lien on the Honda Accord, the cross-collateral clause is telling us, is that lien only secure one loan or does it secure multiple loans? That's all it's telling us. It's describing what the lien secures. It does not create rights to take possession of a car if a loan goes delinquent. So if in that scenario you have a loan document with a cross collateral clause and they have the auto loan, the Honda Accord is the collateral, there's an auto loan and there's a credit card, and the borrower is not paying the credit card, the cross collateral clause does not give the lender the right to take or repossess or recover the Honda because the credit card is in default. What gives the credit union that right is a separate clause that isn't always talked about, isn't as known or discussed, and it is the cross default clause. So some loan documents will have what we call a cross default clause. So when we think about the standard situation, when we talk about default, normally we're talking about failure to make a payment, although that isn't always default. Default can be several things. And the loan document will describe what is default. It will say you're in default on this loan if you fail to make timely payments within the grace period. There'll be a grace period typically. So if you're outside the grace period, you're in default. It will also say, for example, you must maintain insurance on the car. And if you don't, you're in default. It will have other promises that you make. For example, you cannot use the car for an illegal purpose. You can't use it to sell drugs. You can't use it to transport minors across state lines. And those clauses are in there so that if the car is used illegally, the credit union or the lender can take possession of the car and avoid it being impounded by law enforcement, because that is one of the things it's protecting. So a cross default clause simply says you're in default on loan one because you're in default on another loan. That is what creates the right. So going back to the example of the auto loan and the credit card secured by the Honda 2020 Honda, if there is a cross default clause that says you're in default on the Honda loan if you're in default on the credit card, now that gives the lender the right to seek recovery of the auto. It's not the cross collateral clause, it is the cross default clause. And a lot of times clients don't understand, and they simply will say, oh, well, it's the cross collateral clause that gives us this right. And they don't even look to see, does my loan document contain a cross default clause and does it apply to the situation that we're talking about?
I mean, yeah, I think that that's absolutely confusing. I'm glad that you're telling us about the difference between the cross collateral and the cross default clauses.
Yes, Erica, this can be confusing, the difference between a cross collateral clause and a cross default clause. And I think sometimes people think, oh, well, does it really matter? And it does, because they are two separate clauses, and you need to understand which clause gives the lender which power, which clauses are in your documents, and how each clause works.
And that's why your clients love you, because they don't have to be the expert on all of this. They do need to know about it, but if there's a problem, you pick up on it and you can help get them back to where they need to be. and to where they're not making these types of mistakes? I mean, do you see this happening sometimes?
Yeah, I see a lot of mistakes related to this, a lot of confusion. And, fortunately, we are here to help our clients. So when these issues arise, if they call us and reach out to us before they before they take action based upon these things, we can clarify any misunderstandings or help set them on the right course to avoid a legal violation or a compliance violation or a potential lawsuit.
And that's the cool thing about what you do. It is so cool. I think it is that you do the training. And so you might have your staff trained to understand the difference between these two clauses. Then you bring in a few new people and a few people leave. And then all of a sudden the mistakes come back. So you are able to help avoid these very costly mistakes to the credit union by having a training set up, having checks and balances set up so that it's easy to find out when the problem occurs, if the problem occurs, and to rectify it immediately.
Yes, no, training is a big part of what we try to do for our clients, and a great service that we can provide for our clients. And I think because these things are technical, training has to be done to make sure the credit union staff understands they're following the law, they're following what's in the contract, and they understand what they can and can't do, and they can explain it accurately to the borrowers when they're dealing with the borrowers. All those things are very important.
So why don't we talk a little bit about how, can a lender repossess a car if a credit card is delinquent? And the loan documents contain both a cross-collateral clause and the cross-default clause. Is it possible then?
So technically, yes, they can. But our advice would be, instead of repossession, to go through the court process of a replevin. And the reason for that is courts do not look favorably on cross-collateral clauses and cross-default clauses. Sometimes they feel, and it's probably true, that a lot of times when the consumer takes the loan out, they don't understand it. It's in the loan documents. In a lot of cases, these loan documents, these clauses are highlighted, they're in bold, or they're in all caps. But, we all know that when people sign contracts, they rarely read it all the way through. And so, that's one of the things that judges will look at. And so when a judge is looking at whether or not to enforce these provisions, they're going to look at the actions of the creditor, in this case, the actions of the credit union, and has the credit union taken actions or acts that are inconsistent with these clauses. And if they are, the court sometimes will find waiver, meaning that, yes, this clause existed in the contract, but the lender, the credit union, waived that clause by their course of conduct, by their actions. And that gives the court, if you will, an out from enforcing the clause. And so if you had a situation where, as a lender, you repossess the car based upon a defaulted credit card, and the court finds that the lender has waived these clauses, now the repossession is a wrongful repossession, and you are going to face a lawsuit and claims for damages. So the better path there is to file a lawsuit to get possession of the car. If you think you've dotted all your I's and crossed all your T's, then filing that lawsuit protects you from the potential claim of a wrongful repossession. The judge gets to decide, are you entitled to the car or not? And any issues of waiver are going to be addressed by the court there before you have possession of the car. And so that is our general recommendation in those cases.
I mean, and that's really great to know. It's really great that you've cleared this up for us, and that we can see, if this happens, then that should happen. And if this happens, then that should happen. Instead of just kind of doing whatever you think should happen. And it may not be correct. So there was something really interesting that you were talking about earlier, and you were mentioning set-offs, and you said the set-offs is when they can take money from a deposit account and, you know, take care of the balance on a defaulted loan. You said there might be some confusion when it comes to cross-collateral clauses and set-offs. So what is the difference between the two of those, once and for all?
Yes. So there does seem to be a lot of confusion, and to be honest, I don't always understand it, but it seems to be universal. And so a cross-collateral clause, again, simply states in what collateral the lien covers. So, and what loans are secured by that lien. So it purely has to do with collateral other than money on deposit at the credit union. It does not deal with that. Set off deals with money on deposit at the credit union. So set off is the legal right to take money on deposit and apply it to an outstanding loan. So for example, I have $1,000 in my account at the credit union. I have a loan that is outstanding. That loan is delinquent. Set off would give the credit union the right to take money out of my deposit account to bring that loan current. And so one has to do with the right to take money in my deposit account and apply it to a loan. The other has to do with the lien on the car. What loans are secured by that lien? They're two separate things. And they're also separate in the sense of a cross-collateral clause is something that's created in the contract. There's a contractual provision in the contract in order to have a cross-collateral clause. Whereas set-off doesn't necessarily have to exist in a contract because it's a statutory right. There's federal law for federally chartered credit unions that creates the right of set-off, and then there's state law in Florida and Georgia that provide for a right of set-off for state chartered credit unions. So it's not an issue so much of contract law as it is statutory law, whereas there is no statute that creates a cross-collateral clause. They are two separate things, and there are limits on set-off, when you can set off, what you can set off against, how you set off, and those limits do not apply to a cross-collateral clause. They are just two separate things. But I get that question a lot. Well, I can't set off, so does that mean I can't enforce the cross-collateral clause here or the cross-default clause here? And again, they're completely separate.
Wow, that is so interesting. It must be like, I just recently bought an RV, as you know, and I signed up with a credit union for the first time in a long time. And they made me open an account there. And I wonder if that's partially why.
Well, they make you open the account because credit unions are member-owned organizations. So each member has to have a basic share. So your initial deposit is your ownership share in the mutual organization. But they do, most lenders want you to deposit money they want you to bank where you borrow. And part of that is so if you fall behind in payments, they have a source and a way to bring you current. If your paycheck's coming into that checking account and you fail to make your payment, they can take the payment and apply it to the loan. And they usually don't do that unless your loan is delinquent and they've tried to reach you and you've been unresponsive. But it is one of those rights that does exist, like I said, under state law, but it is separate and apart from the cross-collateral clause.
Wow, that is really interesting. And I didn't realize that was my share. So I learned something new today. And I'm very happy with the credit union that I'm working with and the great rates that they have. When you said earlier that cross-collateral clauses do not apply to residential mortgages, I was wondering why that is.
So the loan documents that most credit unions use specifically exclude residential mortgages from the cross-collateral clause. And the reason for this is is that if the mortgage lien, if the lien on the home, the mortgage lien, secured all other loans at the credit union, then every loan becomes a mortgage loan. And when you go and do a mortgage loan, you have all that paperwork you've got to go through. You have these, when you apply, you have an initial disclosures. When you close on the loan, there's all these additional disclosures. That means every loan would have to have all that paperwork in order to comply with the law. So that is just not realistic. That's not practical. That's not the way it's done. So what they do is they specifically exclude it. And so in the context of residential mortgages stand alone. They are excluded. And what happens time to time is I will get this question: Jim, they just paid off their mortgage loan, but they have an overdue or a charged off credit card, and we want to wait and hold off on satisfying the mortgage loan. We want to wait to release the lien on the home until the credit card is paid off, or until they make arrangements on the credit card. And they'll say, we can do that because of the cross-collateral clause. And I will say, no, you can't do that because of the cross-collateral clause. The mortgage is excluded. It stands alone. Whether or not they pay the credit card or any other loans, once the mortgage is paid off, you have to release the lien on the mortgage. And so that is one of those just misconceptions that exist out there. And in a lot of states, Florida is an example, once the mortgage loan is paid off, if the lender does not release that lien within a reasonable time period, then the borrower can actually sue and recover attorney's fees and damages. So if a lender tries to enforce this and doesn't understand that this right doesn't exist, they could face a lawsuit, they could have to pay damages, and those are all things obviously we want to avoid. So this is one of those gotchas that exist out there if someone doesn't understand how the cross-collateral clause is different or separate, doesn't apply to a mortgage loan.
Wow, that was a really good explanation. And who does need all that extra paperwork every time you start a new loan? So that does make a lot of sense. Plus, if you're paying off a mortgage loan, a lot of times you might be needing to move on to a new home. And so they might be taking out another loan very shortly after that with you if they were satisfied. So it's, I guess, better to keep on the up and up with that and let them have that loan. And it's the law. So that's good. Yeah. So why don't we move on to the auto loans and talk about why the cross-collateral clause does not apply when it comes to auto loans?
Well, in this case, it's the indirect auto loan. So there's, in the credit union world, there are you generally break the auto lending down to two types. Direct auto loans. This is where a borrower comes to the credit union, they borrow the money directly from the credit union, and then they go to the dealer and buy a car. The alternative is what has been termed indirect, and so the relationship is indirect. In this scenario, the member goes to the dealer looking for a car. They have not lined up their financing, and the dealer says, oh, if you have this, what's your credit? Is your credit good? If it's good, we can get you financed. If it's not great, we can probably get you financed, but it's going to cost you more. Either way, the dealer takes a credit application from the person buying the car, and then they send it out to their lenders that they deal with. In this case, it could be credit unions, banks, finance companies. Then usually they have multiple lenders they are dealing with, and they seek to have that auto loan or that auto purchase financed. And so the credit unions get what are called indirect loans. They make those loans indirectly to people who are buying the car at the dealership, and those are indirect loans. So we have direct loans and indirect loans. The indirect loans do not have a cross-collateral clause, or I've never seen one in an indirect loan. And that is because you're not using the credit union's loan documents, you're using the dealership loan documents. And the dealerships usually are dealing, as I mentioned, with banks, finance companies. So they have one loan document that they use with all their lenders. And that just doesn't contain a cross-collateral clause. It's not a compliance issue. It just doesn't exist. And so if you have an indirect loan, chances are you don't have a cross-collateral clause. But often credit unions assume every auto loan has it, and they take a position based upon a cross-collateral clause or a cross-default clause. And then when the consumer hires a lawyer and we look at the loan documents, we say, this clause doesn't exist. You've been trying to assert a right you don't have. And of course, that becomes a problem.
Wow, I had no idea that it was different when you buy directly from the dealership versus going and getting your own money from the credit union. That is very interesting. And I think an amazing gotcha for you to let us in on today when it comes to this, because I can see that mistake happening a lot if they just don't understand that buying the car direct means you're probably not going to have any of those clauses at all, because they're dealing with typically financing companies and banks, but not credit unions. So that is very, very interesting. Why don't we talk about the dangers of not understanding the cross-collateral or the cross-default clauses? Because we've talked about a lot of dangers today. That last danger was that they didn't even have the clauses and you're acting like they do. Give us a little bit more information on the difference between the default and the cross-collateral clauses.
Yeah, so, really the danger here is that the credit union employee makes a misleading or a false statement to a member, to a borrower. And that false statement or basically misleading statement leads to a claim or lawsuit under consumer protection statute. Consumer protection statutes are meant to force lenders to deal with consumers in an honest and truthful manner. And we all agree that's what they should do. And so in this situation, it's not that the lender is purposely misleading the consumer. It's the lender themselves are misled, but they're making misleading statements. So whether it's intentional or not, it's still a violation of the law. And those things can cause harm to the borrower, cause the borrower to take legal action against the lender, and the lender now has to pay a lawyer to defend that, probably has to pay money to settle that lawsuit. And then worse, even a bigger threat is that the credit union improperly proceeds with repossession and then faces a lawsuit over a wrongful repossession, because wrongful repossession lawsuits are always expensive. They're a nightmare to defend. They cost a lot of money because usually the car has significant value, and the loss of use of that car to the borrower raises the damages. So these are cases that aren't settled for thousands of dollars. They can be tens, 20s, 30, 40 more thousands of dollars to get these cases settled. And they draw a lot of negative press, i.e., hey, this credit union takes people's cars illegally. I mean, that's the news story. And no one wants that news story. It's much different than, this credit union unintentionally violated some consumer law that nobody understands. That doesn't have the same sting. That doesn't have the same negative impact. But when you take someone's car that you weren't legally entitled to take, everybody understands that. Everybody thinks it's wrong, and everybody looks at that lender in a very negative light. So the damages can be quite substantial.
I mean, it sounds like it. And you're right. Bad news travels fast. And that can cost you a lot more than a lawsuit. That can cost you a lot of future customers, may even cost you your business. So, Jim, the most important question today is, how can you get your employees to understand these clauses and the very negative impact on the credit union if they don't get it right.
Yeah, so I think starting is procedures, having well drafted procedures that address the use and scope of cross collateral and cross default clauses. A lot of times when we look at procedures at a credit union, this topic is not addressed at all, or if it is addressed, it's a blip, a sentence or two. And it gives the staff, it gives the employees of the credit union no guardrails within which to operate. And so I always like to think of your procedures as your guardrails, right? You want to keep people within the lanes of traffic that they should operate. And so the guardrails are there to help them. And then in addition to that, you want to have training. And we talked about this briefly, but training becomes so important. Does the staff understand cross-collateral clauses, cross-default clauses? There's other training that needs to be done, and we've talked about this before, but this is one of those trainings. And then actually, as part of that training, having staff read the loan documents and understand them. It is always amazing to me how many times I go into a credit union and the staff has never read the documents, the loan documents, the contract that they are trying to enforce. It seems basic, but for some reason that part is skipped over. And to me, a good credit union employee who's dealing with this in and out should know where that clause is in the contract, should be able to point the consumer to it, because a lot of times, we've already talked about this, consumers don't realize that when I've given that lien on my 2020 Honda Accord to ABC Credit Union, that lien not only covered my auto loan, but it covered my credit card, or it covered my personal line of credit or vacation loan, whatever, you pick the other loan. They don't understand that. And so when they first hear that, they question it. Where was that in my loan document? And the staff person, the credit union employee saying simply, well, it's in there, is not very helpful. As opposed to, well, I can send you a copy of the loan document and I'll circle the clause so you can see it, right? That is much more helpful. Oh, you know what? I didn't read that. I didn't understand it. I see that now. Doesn't mean they're going to like it. Doesn't mean they might not agree, but they now understand that that is in the documents, and it helps your staff be much more effective. And so, those are things that we try to help our clients with: how to train your staff, and do you have effective procedures in place that act as those guardrails on these issues?
Well, I mean, I think that's great. And, even if they don't remember everything that's in the contract, at least knowing where most of the questions pop up and knowing where the major points are that they need to point out to their clients would be extremely helpful, I would think.
Yes. Oh, definitely.
I mean, no one's expecting them to be a lawyer, but they should at least know the basics.
That's correct.
Well, I think this was a really great topic, and it's going to clear up a lot of confusion. I think that might be out there. And I know we've got some great graphics up on the definitions of these clauses and the differences. And, I'm really glad we had this discussion. So I want to thank you so much for taking the time to put this information together for us and to present it here today.
Thank you, Erica, for having me. And I look forward to speaking with you again on another myth that we can bust.
All right. We love busting those myths. And for all of you out there that are working with credit unions, working for credit unions, own a credit union, then you need some help with these sorts of issues and you're finding these mistakes coming up from your employees, definitely give Jim and his law firm a call, because they're absolutely amazing. They're honest, they're down to earth, and they will make this much easier to understand than just trying to train your employees on your own on this stuff, or maybe not even training your employees. Just kind of seeing what happens, which is never a good thing. So thanks everyone for listening, and I will look forward to talking to you again very soon.
Thank you, Erica.